Just as an agent has duties towards the principal, he is also entitled to certain legal rights for the work he performs. First, the right to retain under Section 217. Second, the right to remuneration under Sections 219 and 220. Third, the right of lien under Section 221. Fourth, the right to indemnity under Sections 222 and 223. Fifth, the right to compensation under Section 225. Let us discuss these rights one by one. The first right is right to retain. As per Section 217, an agent may retain, out of any sums received on account of the principal in the business of the agency, all monies due to himself in respect of advances made or expenses properly incurred by him in conducting such business, and also such remuneration as may be payable to him for acting as agent. According to this provision, an agent has the right to retain certain amounts out of the money received on behalf of the principal. Specifically, the agent may retain any advances made by him, any expenses properly incurred in conducting the business of the agency, and also any remuneration or commission payable to him for acting as an agent. In simple terms, before handing over the remaining money to the principal, the agent is legally allowed to deduct all lawful dues owed to him. This right ensures that the agent is not left out of pocket while performing his duties. It also protects the agent by giving him a direct way to recover his legitimate expenses and earnings. Section 218 of the Indian Contract Act deals with the agent's duty to pay sums received for the principal. According to this provision, the agent is bound to pay to the principal all sums received on his account. However, this duty is subject to certain deductions. As we have already discussed, the agent has the right to retain his lawful dues, such as expenses incurred, advances made, and remuneration. After making these legitimate deductions, the agent must pay the remaining amount to the principal without any unnecessary delay. The agent cannot withhold the money, use it for personal purposes, or delay the payment without valid justification. The second right is right to remuneration. An agent is entitled to get an agreed remuneration as per the contract. If nothing is mentioned in the contract about remuneration, then he is entitled to a reasonable remuneration. But this right is not absolute. If the agent is guilty of misconduct in the business of the agency, then he loses his right to remuneration. Section 219 of the Indian Contract Act, which explains when an agent's remuneration becomes due. According to this provision, in the absence of any special contract, an agent is not entitled to receive payment until the completion of the assigned work. This means that remuneration is generally payable only after the agent has successfully performed the act for which he was appointed. However, there is an important exception. An agent is allowed to retain money received by him on account of goods sold, even if the entire consignment has not yet been sold, or the sale is not fully complete. This means that once the agent has started performing his duties and has received some money, he can retain his dues from that amount. Section 220 of the Indian Contract Act deals with a situation where the agent is guilty of misconduct. According to this provision, if an agent commits misconduct in the course of the agency, he is not entitled to receive any remuneration for that part of the business which has been misconducted. In simple terms, if the agent acts dishonestly, negligently, or in breach of his duties, he cannot claim payment for that particular work. It is important to note that the agent may still receive remuneration for the part of the work which has been properly performed, provided it is separable from the misconducted part. This rule ensures that the agent is rewarded only for honest and proper performance, and not for wrongful conduct. Let us now understand this concept with an illustration. A employs B as an agent to recover 1 lakh rupees from C and to invest that amount in good security. B successfully recovers the full amount of 1 lakh rupees. Out of this, he invests 90,000 rupees in safe and proper securities. However, he invests the remaining 10,000 rupees in a security which he ought to have known was unsafe. As a result, A suffers a loss of 2,000 rupees. Now, what is B's position? B is entitled to remuneration for the work properly done, that is, for recovering the 1 lakh rupees and for correctly investing the 90,000 rupees. However, he is not entitled to any remuneration for the improper investment of 10,000 rupees. Additionally, B must compensate A for the loss of 2,000 rupees caused due to his negligence. This illustration clearly shows that an agent is rewarded only for the part of the work performed properly, and not for the part affected by misconduct. Let us now understand another illustration. A employs B to recover 1,000 rupees from C. However, due to B's misconduct, the money is not recovered. In this situation, B is not entitled to any remuneration for his services. Why? Because the work assigned to him was not completed due to his own fault or negligence. Moreover, B is also liable to compensate A for the loss caused. This illustration makes it very clear that if an agent fails to perform his duty due to misconduct, he not only loses his right to remuneration but also becomes responsible for the loss suffered by the principal. The third right is right of lien. An agent has the right to hold back or retain goods or other property of the principal received by him till the time his dues or other payments are made. In other words, we can say that this right allows the agent to retain or hold back the goods, property, or documents of the principal that are in his possession. In simple terms, the right of lien acts as a security for the agent. According to Section 221, in the absence of any contract to the contrary, an agent is entitled to retain the goods, papers, and other property of the principal that come into his possession. This right applies to both movable and immovable property. The agent can retain such property until all amounts due to him are fully paid or properly accounted for. These dues may include his commission, expenses or disbursements incurred, and payment for services rendered in respect of that property. In simple terms, the agent can hold the principal's property as security until he receives what is rightfully owed to him. However, this right exists only if there is no agreement restricting it. Fourth right of an agent is the right to indemnity under Sections 222 and 223 of the Indian Contract Act. An agent has the right to be indemnified by the principal for all expenses and losses incurred while acting in the course of the agency. According to Section 222, the principal is bound to indemnify the agent against the consequences of all lawful acts done by the agent in the exercise of his authority. This means that if the agent acts within the scope of his authority and performs lawful acts on behalf of the principal, then any loss or liability arising from such acts must be borne by the principal. The agent should not suffer personally for acts done in good faith and within his authority. Let us now understand the right to indemnity with the help of two important illustrations. First, illustration A. B is an agent at Singapore, acting under the instructions of A, who is in Calcutta. B enters into a contract with C to deliver certain goods. However, A fails to send those goods to B. As a result, C files a suit against B for breach of contract. B informs A about the legal proceedings, and A authorizes him to defend the suit. B defends the case, but ultimately has to pay damages, costs, and also incurs legal expenses. In this situation, A, the principal, is liable to indemnify B for all such damages, costs, and expenses. Why? Because B acted according to A's instructions and within his authority. Now, illustration B. B is a broker in Calcutta, and under A's instructions, he contracts with C to purchase 10 casks of oil. Later, A refuses to accept the goods. C then files a suit against B. B informs A, but A completely denies the contract. B defends the case but loses, and has to pay damages, costs, and other expenses. In this case also, A is liable to indemnify B. This is because B acted in accordance with A's instructions, and the loss arose due to A's refusal. These illustrations clearly show that when an agent acts lawfully and within authority, the principal must bear the consequences and compensate the agent for any losses incurred. Section 223 deals with indemnity for acts done in good faith by the agent. According to this provision, when a principal employs an agent to do a particular act, and the agent performs that act in good faith, then the principal is bound to indemnify the agent. This is true even if the act results in injury to the rights of a third person. In simple terms, if the agent honestly follows the instructions of the principal and acts without any wrongful intention, then any resulting consequences must be borne by the principal. The agent should not suffer for acting in good faith and within the scope of his authority. However, it is important to note that this protection applies only when the act is lawful and done honestly. Let us now understand Section 223 with the help of illustrations. First, illustration A. A is a decree holder and is entitled to execute a decree against B's goods. A instructs a court officer to seize certain goods, claiming that they belong to B. The officer, acting on A's instructions, seizes the goods. However, those goods actually belong to C, the true owner. As a result, C files a suit against the officer and recovers compensation. In this situation, A is liable to indemnify the officer for the amount he had to pay to C. Why? Because the officer acted in good faith and followed A's directions. Now, illustration B. B, at the request of A, sells certain goods that are in A's possession. However, A had no legal right to sell those goods. B is unaware of this fact and, after selling the goods, hands over the sale proceeds to A. Later, C, the true owner, sues B and recovers the value of the goods along with costs. In this case also, A is liable to indemnify B. A must compensate B for the amount he paid to C and also for the expenses incurred. These illustrations clearly demonstrate that when an agent acts in good faith and follows the instructions of the principal must bear the consequences, even if third-party rights are affected. Section 224 lays down an important limitation on the right to indemnity. According to this provision, when a person employs an agent to do an act which is criminal, the employer is not liable to indemnify the agent for the consequences of that act. In simple terms, if the agent commits a criminal act, even under the instructions of the principal is not responsible to compensate the agent. The law does not protect illegal or criminal activities. So, even if there is an express or implied promise of indemnity, it will not be enforceable in such cases. The agent will have to bear the consequences of his own criminal conduct. This provision clearly establishes that indemnity is available only for lawful acts done in good faith, and not for unlawful or criminal acts. Let us now understand Section 224 with the help of illustrations. First, illustration A. A employs B to beat C and promises to indemnify him against all consequences of the act. B follows A's instructions and assaults C. As a result, B has to pay damages to C. In this case, A is not liable to indemnify B. Why? Because the act of beating C is a criminal act, and the law does not allow indemnity for illegal or criminal conduct. Now, illustration B. B is the proprietor of a newspaper. At the request of A, B publishes a defamatory statement, that is, a libel against C in the newspaper. A promises to indemnify B against all consequences, including costs and damages. However, C sues B, and B is required to pay damages and also incurs legal expenses. Even in this situation, A is not liable to indemnify B. This is because publishing a libel is a wrongful and unlawful act, and indemnity cannot be claimed for such acts. These illustrations clearly show that the law does not protect agents involved in criminal or illegal acts, even if they acted under the instructions of the principal. Fifth right of an agent is the right to compensation under Section 225 of the Indian Contract Act. According to this provision, the principal is bound to compensate the agent for any injury caused due to the principal's neglect or lack of skill. In simple terms, if the agent suffers harm because the principal was careless or failed to act properly, then the principal must make good that loss. Now, let us understand this with an illustration. A employs B as a bricklayer to construct a house. A himself arranges the scaffolding required for the work. However, the scaffolding is put up in an unskillful and unsafe manner. While working, B gets injured due to this defective scaffolding. In this situation, A is liable to compensate B for the injury suffered. Why? Because the injury was caused due to A's negligence and lack of proper skill. This provision ensures that the agent is protected from harm caused by the principal's fault.